This is your Spotlight on Now on the Now Morning Show. I'm Kimerly De Souza. Now, in a recent judgment involving the Equal Opportunity Commission, the Court of Appeal recognized that sexual harassment can be a form of sex-based discrimination in employment, which is prohibited by the Equal Opportunity Act, Chapter 2203. So to talk more about sex-based discrimination in the workplace is Director of Legal Services at the Equal Opportunity Commission, Mr. Haran Ramkaransingh. Mr. Ramkaransingh, good morning, and thank you so much for joining us on Now.
Good morning, Kimerly. Thank you for having me. Good morning, Trinidad and Tobago.
Now, tell us about the Equal Opportunity Commission. I mean, who are they, and just a little bit about the work that the Commission does.
Certainly. We are a public body. We are created by an Act of Parliament. You just mentioned the Equal Opportunity Act. So we are created by this Act, and our mandate is to enforce the Act. The Act was passed to prohibit certain kinds of discrimination. So, for example, it prohibits discrimination in four broad areas, that is employment, education, the provision of goods and services, and the provision of accommodation. But that discrimination must be tied to what are known as status grounds, and these are personal and inherent characteristics. And I normally throw it out to people to think about what are your characteristics that you have that you could be discriminated against. And the Act protects against only certain characteristics, such as your race, your ethnicity, your religion, your sex. And the statistic opinion, sexual harassment falls within that ground of sex. Your origin, your disability, and your marital status. So those are the grounds that are protected by the Equal Opportunity Act. So if you were in your employment, you were discriminated against because of your race or your religion or your disability or that sort of thing, you can lodge a complaint with us. Our mandate is to receive the complaint where possible, to investigate the complaint, and where possible, conciliate it. That is, we bring the parties to the table to see if they can have a discussion to resolve it. If it cannot be resolved, the Act created a second institution, and that's the Equal Opportunity Tribunal, and they are a court. They are chaired by a judge, and their mandate is to hear the matter and determine the matter and render a judgment, just as any court would. So they function really as a court. They are separate to us and independent to us, but they are part of the equal opportunity process.
Right. Now, since sexual harassment falls under one of the mandates, what in your simple definition is sexual harassment?
Well, sexual harassment is any unwelcome conduct, and we always like to stress that there must be an unwelcome conduct. There must be an unwelcome element to it that makes the receiver feel offended, humiliated, or harassed or intimidated. Where it's a bit tricky because it must be something that a reasonable person would perceive as being harassment, but at the same time, it's also subjective in that you have to look at how does the victim receive this conduct. And that's where the welcomeness or the unwelcomeness comes about. So, for example, compliments in a social setting would not be not be considered sexual harassment.
Right.
But at the same time, there are times that the compliments, let's just say you're in a bar, I'm using an example, the compliments perhaps may go a bit too far. But it is incumbent upon the person receiving it, to perhaps indicate that, okay, this is fine, this is enough, because at the same time, maybe the person who's doing it may not fully appreciate what they're doing is a form of harassment. So there's a lot of dynamic about it because, there has to be some, there are certain conducts that we say might be borderline, but then there are certain conducts that are clearly not borderline, that are clearly intended to offend, and intimidate, and harass a person.
Right. Because I was just wondering, what if it is, somebody, and this is moving further away from the compliment, but you give somebody something or you say something about somebody and then they interpret it the wrong way. I mean, who is the wrong one in that situation? Is it the person who said the thing or the person who was offended by the comment?
Well, I don't think there's such a thing as a person who's wrong. Let's just say a person leaves, so say chocolates on your desk, and you perhaps interpreted it the wrong way. But it's incumbent upon you to say, well, no, I don't appreciate this. Because if you look at it objectively speaking, say leaving some chocolate for somebody or some flowers is not necessarily an offensive thing. It's actually a very nice thing. I would like to receive chocolate on my desk, So that's why we say that it has to be something that would be reasonably perceived as harassment. But at the same time, if you feel harassed, you need to say that you feel harassed because it's about your dignity at work.
Right. Now, I was reading about there's a difference between the term sexual harassment in the workplace and sexual harassment in the world of work. Yes. What is the difference between those two?
Well, you see, people tend to think about sexual harassment as something that happens in an office. In the context of employment, it has to be sexual harassment in the context of employment. But what we like to say is that The harassment may not necessarily take place in the office where you do your work. The harassment, for example, could take place in a company vehicle or even in any ordinary vehicle driving. Let's say you and that person, I'm using the context of TTT News, you have to go somewhere to Point Fortin, you know, to look at the story you all were talking about in Claxton Bay.
Right.
So you're driving in a vehicle to go to that story. And the harassment could take place in that vehicle. Even after the story, you say, look, let's get lunch. Let's go somewhere and get lunch. We're hungry. The harassment could take place in that restaurant or bar, wherever it is you go to get lunch. Let's say you're privileged enough to go to abroad to do a story, and they send you abroad and they put you up in a hotel. The harassment could take place there. And now, again, the vehicle, the restaurant, the hotel, that's not really the workplace. That's not really the office. But so that's why we say if you confine it to purely something that happens in the office, you might get a distorted view, because you might say, well, this didn't happen in the office. This happened when you and me were in a hotel or in Claxton Bay looking into the story. So that's why we say you have to look at it not just as an office event, but something that happens in the world of work, because all of this is part of the world of work. Going to Claxton Bay or Point Fortin to look at the story, that is part of your work.
Right, of course. Now, what happens when you bring the complaint to the EOC? What is the process after that?
Well, we would always call the person has to lodge a complaint. Sometimes people used to ask, well, did you see this happening in the news? What are you going to do about it? And we said, no, we are a complaint-based system, in that you have to lodge a complaint. The victim has to lodge a complaint, and then we would call the person for a meeting, and then we would start an investigation. More often than not, we would write to the employer or to the person against who the allegations have been made, and ask them to give their side of the story. Just earlier this morning, you were talking about due process. Yes. There must be due process.
Yes.
So that we have to say, well, these are the allegations against you, and what is your response? Sometimes persons had asked, well, can you, if I make this complaint, can you conceal my identity? Now, for public documents, we would. So let's just say we have to publish a report. We would always redact the person's name. But if I have to write to a person and say that an allegation has been made against you, we have to let the person know, well, so-and-so has made this allegation against you. Because, again, due process. We can't say an allegation has been made against you, but we can't tell you who's made the allegation or what they've said. That's not due process. So you would write to the person and see what their response is. Based on their response, we might have further questions. So we might try and get more information. We also, in our investigations, we try to look for what is called contemporaneous evidence. So let's just say you said that this happened to me, and I'm just using an example in the back of the studio. We say, okay, well, let's write to TTT. Do you have cameras? Do you have surveillance systems? So apart from writing the person who we made the allegation against, we could write other persons. Any persons who might be a witness, the security guard, see anything, what are the logs of the securities, what time did the person come, what time did the person leave. So we try to do a complete and holistic gathering of the evidence. Based on what we gather, we can look at referring the matter to conciliation, because it might be that the matter could be conciliated, it could be resolved if the parties were to sit down around a table and have a discussion. There are some matters that by their nature they can't. I mean, but sometimes we always try to see, well, maybe let's just see if you can talk it out and see if you can reach somewhere with it.
Before it goes to tribunal
before it goes
and Court of Appeal.
Yeah, before it goes to the tribunal.
Right.
And if not, then it can go to the tribunal,
right.
which, as I said, is a separate institution, and they're a court. As with any court, the proceedings before us, you don't need to have an attorney. You can if you want to, but it's not necessary. But when you go to a court, you have to have an attorney, and it's like going to the High Court, to the Industrial Court. You have all these rules, you have pleadings, you have all these little documents. You have to file your witness statement, your affidavits. So that's really a legal process, and so that's the next step of the process, really.
Nice. Now, the recent judgment that we are talking about is that the judge ruled that sexual harassment was a form of sex-based discrimination. How so?
Well, it is seen as sex-based. Well, to begin with, there is no standalone legislation in Trinidad and Tobago dealing with sexual harassment. So that a person who is a victim of sexual harassment has to try and get relief by perhaps what we call, for want of a better word, pigeonholing, or fitting that offensive conduct into some existing legal remedy. So under the Equal Opportunity Act, for example, the Act prohibits discrimination in employment on the ground of sex. Now, courts internationally, because our Equal Opportunity Act is patterned after equal opportunity legislation in other countries, and it has been ruled internationally that sexual harassment can fit within sex discrimination in employment in circumstances where a person has suffered a detriment because of their sex. That is to say, I'm using the example, a man who is harassing a woman would not necessarily harass a man in the same manner. So let's just say, let me flip around the example, because we always think about a man harassing a woman.
But it can happen the other way as well.
Because
yes.
actually, the same Court of Appeal matter you spoke about was actually the opposite. It was actually a male employee complaining that his female supervisor had harassed him.
Right.
So let us use that example. What he is saying is that, and these are purely allegations. I don't want to say that this happened or didn't happen. That has to be proven in court. But let's just take the allegations at face value. His allegations are that I was harassed by my female supervisor. It is seen as sex discrimination because the female supervisor will not go about harassing female employees the same way. His allegations are that she told me things, and she called me names, bae and hottie and these sorts of things. I mean, I'm a bit older, so this was kind of a learning experience for me. What is a
Some
bae?
new language to learn.
Yeah, so
yes.
she called me bae and hottie, and so the concept is that this lady will not be telling other females bae and hottie and niceness and that sort of thing,
right.
which is what she told him. So in other words, because one might argue that there might be other reasons why she might have allegedly harassed him, but what we're saying is one of the reasons why she harassed him was because he was a male. And so therefore, because he was a male, he suffered this detriment that if he were a female, he would not have suffered.
But Mr. Ramkaransingh,
yes.
I mean, we have a growing LGBTQIA population locally, right?
Yes, yes.
So the argument that, the female supervisor may not make those same comments to a female might be kind of wrong, because
yes.
what if the female supervisor is attracted to someone of the
yes.
same sex?
Well,
so how does that factor into
well,
this?
actually, right now, I can't discuss it, but we're actually dealing with two matters, two complaints, where two male employees said that they were harassed by a male supervisor. So it fits in the same way, because if this male supervisor is homosexual, again, he would not harass a female employee the same way he would harass a male employee. So in that sense, a person's sexual orientation, a person can get relief regardless of their sexual orientation, as long as they're saying that I'm suffering a detriment because of my sex. So that let's just say the female supervisor is sexually harassing a female employee. That female employee can get relief if she can say, well, this lady doesn't harass the males. She's only harassing, she harassed me as a female, but she's not treating the males in the same detrimental manner. So in other words, one's sexual orientation doesn't necessarily fit into the relief, because the issue is, are you suffering a detriment because of your sex?
Right.
However, just to stick a pin, the difficulty with this approach, though, is that let's just say the manager is bisexual and is harassing both males and females.
And females, yes.
Then you might have a difficulty there. Then you may not be able to get relief under the Equal Opportunity Act, because you're not suffering a detriment because of your sex.
Because of your sex, exactly.
Yeah, because both the males and females are suffering the same detriment.
So in a situation like that, then what can the argument be?
Well, in a situation like that, we have advocated that there should, apart from our system, that the Attorney General needs to look at bringing legislation to deal with sexual harassment, because that example I just gave of the bisexual manager who's harassing both male and female, unfortunately, under the Equal Opportunity system, they would not be able to get relief. They might be able to perhaps take the matter to some other system, the Industrial Court or the High Court, to sue for some other form of
relief.
Some other form of relief,
yes.
but they wouldn't be able to get relief with us. So this is one of the things that why we've said that it is desirable to at least have legislation to deal with sexual harassment.
Right. Now, of course, we are talking about the issue of having the legislation brought forward.
Yes.
I know that consultations were taking place. I mean, do you have an update on that, of how we're moving forward with that?
Yes. Well, the consultations had taken place with the former Attorney General, Mr. Al-Rawi, and he had referred it to the officers in his ministry to draft the appropriate legislation. He did say that he was awaiting the judgment of the Court of Appeal in this matter before proceeding. Well, he's no longer the Attorney General, so it's something that we would now have to pursue with Mr. Reggie Amo, who's the new Attorney General, to perhaps reignite the burner on this matter. I think it was a practical thing that Mr. Al-Rawi said, that he didn't want to jump the gun if the matter was before the Court of Appeal. So now the Court of Appeal only decided this matter earlier this month. So it's something that we would probably just need to restart the process and see how far it's gotten.
Right. Now, one of the things in the report, because I saw the report in terms of the case, in terms of the gentleman who brought the case against his female supervisor. Now, the Court of Appeal chose to limit the use of the term sexual harassment and instead speak about detriment because of sex. So sexual harassment by itself is not a ground for complaint, but it has been subsumed under sex discrimination.
Yes.
Does this? Well, this obviously limits the work of the Equal Opportunities Commission. And are you looking to see how you can broaden the range about what you can do and how you can get involved?
Yes, and that's why I think that if the Attorney General were to go forward with the proposed legislation on sexual harassment, that could perhaps broaden the range, because then persons can complain of the harassment itself as opposed to saying detriment, as opposed to sex discrimination. At the same time, the legislation might also look at what other remedies they can get, or the different forms of remedies that they can get, whether they can get, for example, injunctive relief, whether they can get, because, for example, right now, one of the complaints we're dealing with is with a lady who said she was harassed in her job. The employers did an investigation and they terminated the manager. But then she's saying that, you know, while you did that, I have suffered a lot of trauma and I'm not getting anything from my employers. They told her, well, you can take your vacation days. And now I don't think that's now I don't, perhaps maybe the employer themselves don't know what to do, but I really don't think telling a person, well, take your vacation days is an appropriate remedy. So these are things that we would like to look at in terms of what remedy or what relief you can grant to someone who has been harassed. For example, the lady said, I had to pay money to consult an attorney because I didn't know what was going on. I was traumatized. You know, and these are sort of things. Well, the employer is sort of saying, well, well, sorry, that's your choice, which I don't think. I mean, to be fair, you look at it from the point of view of an employer, that you don't want somebody going out and expending all this money and then saying you have to compensate me for that. But at the same time, telling the person take your vacation days is not really the appropriate response on the part of the employer.
I mean, we only have about 1 more minute, but final question. What sort of disciplinary action is taken against the offender when things like these happen? I mean, we just spoke about, you know, the person being terminated. Yes. Is that a norm?
Well, it depends on the nature of the infraction. For example, it could be that the perpetrator themselves receives some sort of counseling. They're sent on that, because we don't want to say that, you know, the guillotine has to fall on every person. You have to look at the degree of the harassment, and you know, there's some conduct by itself that would justify termination, but there are other types of conduct that you may say, look, what you need counseling, you need treatment, you need assistance, that sort of thing. So right. So there are a number of things that an employer can do because we spoke about I just spoke about assisting the victim, but also sometimes you have to think about assisting the perpetrator as well.
Of course, yes,
you know, you don't want to leave that person high and dry on the side of the road, for want of a better word.
Mr. Haran Ramkaransingh, the Director of Legal Services at the Equal Opportunity Commission, just giving us, you know, some updates on the recent ruling about sex discrimination and its relation to sexual harassment. You are on the Now Morning Show, Mr. Ramkaransingh. Thanks so much for joining us. So now, as always,
thank you very much.
We're going to take a quick break, and up next, you are going to be hearing from a Trini artist whose artwork is going to be featured in a museum in Seattle. Stay with us.